Hi, my name is Dinesh. Today our group is discussing about ASIC versus HELLICAR case, and I'll be talking about the introduction, background, and also decision of court at first instance. For the introduction, High Court of Australia overturned the decisions made by NSW, New South Wales Court of Appeal in Morley versus ASIC and Shafrin versus ASIC case, and in this case, seven non-executive directors and company secretary general, they have released a misleading announcement or a misleading statement which is false, and to the Australian Stock Exchange. And there are three significant reasons which are important in this case. And the first one will be false and misleading statements, and clarification of the importance of accurate time taken for board meetings, and on the High Court's perceptions whether ASIC as a common penalty proceedings prosecutor has an exceptional obligation of equity. That means special duty of justice. And the contemporaneous judgment made by the High Court in Shafrin versus ASIC explains the scope of company officers' position. And and the background of background to the High Court's judgment is JHIL James Hardie Industries Limited has an exposure to compensate asbestos disease victims because of the company's business activities of two wholly owned subsidiaries, which is James Hardie and Coy Private Limited and Jessica Private Limited, to the year 1987. JHL, although JHL was the ultimate holding company at that time, the directors of JHL decided to establish an organization that would manage the asbestos claims. Which means the people, staff who were actually affected by the asbestos-related diseases while working for the company. So the separation is achieved by the JHL by starting a foundation which is called MRCF, which is Medical Research and Compensation Foundation. And MRCF Foundation operates and pay out asbestos claims and to carry medical research into the causes of treatments for asbestos related diseases. The management and the board members discuss the requirements for the plan to establish a foundation. So the JHL was split and divided into two subsidiaries, which is James Hardie and Coy and Jessica Private Limited, and entered into a deed of covenant and indemnity for asbestos claims. Company agreed to pay the substantial amount to the foundation, but they failed in making the claims legitimate compensation, and also they anticipated the foundation. They also made a misleading statement which says the foundation has sufficient funds for the company shareholders and asbestos claimants, and not only them, to the Australian State Exchange. It became apparent that the foundation was very substantially underfunded to pay out the claims more than $1 billion, and the statements were misleading and non-materialistic. So, decision of court at first instance was according to civil penalty proceedings brought by ASIC in the Supreme Court of New South Wales against the executive and non-executive members of JHL for contravening S180 Act 1 of the Corporations Act 2001. ASIC charged that the board individuals from JHL, after its meeting on 15th February 2001, the organization had endorsed a draft declaration to ASX, which is Australian Stock Exchange, contained explanations which are deluding about the adequacy of the assets accessible to the MRCF, to meet present and also future cases. SIC additionally found that the successor of JHI's JHINV had occupied with deluding conduct and different negations about a resulting financial specialist, and the court held that JHL non-executive chiefs, NEDs, and the CEO, the CFO, Mr. Morley, Mr. Shafrin, Joint Organization Secretary General, General Advice Executives, Administration broke their particular statutory obligations of duty of care and diligence according to the S180 Act, and the individual respondents were ordered by the court to pay financial punishments in the form of pecuniary penalties, and precluded them from overseeing partnerships and managing corporations. And the remaining part of this SIC case will be explained by my group members. And
Hi, I'll be talking about the Supreme Court of NSW decision as well as the Court of Appeal decision. So the Supreme Court of NSW originally ruled that the directors had approved the misleading ASIC announcement by reason of their approval of the draft announcement. So, in summary, Justice Gazelle has held that firstly, the draft announcement was approved. Secondly, it was false and misleading because of the reference to the MRCF having sufficient funds to meet all legitimate asbestos claims and being fully funded. Thirdly, Mr. Chevron, the company secretary, had failed to advise the board about the limitations of the economic model supporting the fund of the MRCF, and also failed to consider whether JHIL was required to disclose to the ASX a deed of covenant and indemnity between JHIL and its subsidiaries. And lastly, the 9 directors and 1 officer had breached the Section 180 of the Corporations Act 2001. So the 7 non-executive directors concurred at the board meeting that they did not approve the announcement, but Justice Gazelle found that the draft was indeed discussed and approved because the minutes referred to that as being occurred and were subsequently approved by all of them. And I'll proceed to talk about the Court of Appeal decision. So the Court of Appeal overturned Justice Gazelle's findings against 7 non-executive directors on the basis that ASIC had failed to discharge its onus of proof and establish that the draft AXS announcement had been approved at the board meeting. So the Court of Appeal relied on 3 points. Firstly, no witnesses have been called who could specifically recall the approval. Secondly, ASIC failing to call the principal legal advisor, Mr. Rob, who was present at the board meeting. And lastly, the mistakes in the minutes, which indicated that they may not be a reliable source of what happened. However, the Court of Appeal upheld the finding that Mr. Chevron, the company secretary, had indeed failed to advise the board about both the limitations in the economic models projecting future asbestos liabilities and of the board's duty to disclose to the deed of covenant and indemnity. Thank you.
Hello, I'm going to describe about High Court decision and reasons for the decisions for ASIC versus HELLICAR case. The hearing result from the High Court has caused by ASIC's appeal of determination from Supreme Court. The appeal court had asked the applicant to provide its evidence, but they failed to provide the evidence beyond a reasonable doubt, and also failed to present the person who drafted the meeting minutes, which was supposed to be presented as an evidence for ASIC. Meeting minutes are really important in that case, but the High Court wasn't satisfied with the submission of the reported minutes because they had prepared the minutes before February 15th and the information was not accurate. Since there was no board meeting on March, which indicated on the February minutes that contained misleading resolution and it had not been passed. Without this, the High Court also figured out persuasive and implicating evidence regarding the draft ASX announcement, where the separated worker served as executive. Under Section 251A of the Corporation Act 2001, the minutes should be recorded within 1 month. But in the case, the High Court found that the minutes of 15th February board meeting provided evidence for ASIC's case, which were not convincing. Additionally, the High Court had criticized the Court of Appeal for going wrong in overlooking the cogency of ASIC's evidence as minor arguments. And for the final point, the High Court again criticized ASIC for hiding Mr. Rob, who was the lawyer regarding that case, would have been an important source in sustaining its case. So finally, after analyzing all the facts and evidence, the High Court overturned the Court of Appeal's decision and forwarded the matters to New South Wales Court of Appeal for redetermination in light of relief from liabilities and accruing penalties. Thank you.